Hey guys, so welcome back to our Admin in Action, where the podcast where we talk the serious world of laws, regulation, and courtroom drama and turn it into something you can actually enjoy and not risk to sleep in your office. So in our previous episode, we was talking about the family law, where we was focusing on the family divorce and so on, where we literally focusing on the procedure and how things looks like. And in the previous episode before that, we was talking about the criminal cases where most of you was interested because it was so interesting. And for today's episode, we're going to focus about the administrative law, and especially we are going to focus on the tribunals. So before I start talking about the tribunals and we are going to focus on today's case, let me introduce our panel of guests first. So with us, we have legal minds such as Jasper, and then we got Samuel, we got Chen, and we got Cor. And what is actually tribunal means? So tribunal is basically what a court that actually emphasizes on a specific case. In Malaysia, tribunals are specialized in quasi-judicial bodies created to resolve a specific types of disputes. These are designed to focus on a particular issue that happens in a specific body. And here are some key examples. For example, it's the industrial court, and then where the handles disputes between employees and employee, including the unfair dismissal, redundancy, and collective bargaining disputes. And besides that, I also have a few other examples. For example, is the labor tribunal and also the special tribunal for supply management. And what tribunals have in common is that they bring specialized expertise to subject matter. It means that they actually focus on matters that are with the specialized person, so that it's easy to come out with a solution in a shorter period of time compared to a general court. And besides that, it resolves disputes more efficiently and then the traditional court system. And let's, without further ado, we focus on today's case. So today's case is basically where we will focus on a real life scenario that actually happened, and we will analyze the file according to issue, law, application, and conclusion. So the case is basically where the Malaya Textile Sdn Bhd, a major garment manufacturer in Penang, recently carried out a restrictive exercise. Several long-serving employees were terminated on the basis of redundancy. That's actually sad, guys. And the union isn't pleased. They alleging unfair dismissal and claiming the company breached their collective agreement. On the other side, management argued that, oh no, we are not wrong. We actually was lawful and necessary followed all the necessary regulation under the Industrial Relation Act 1967. And now, the Minister of Human Resources has officially referred the dispute to the Industrial Court for further details. So, without further ado, let us start with Jasper, where he will explain the issue that he actually finds in this case.
So the issue in this case is whether the termination of the employees by the Malaya Textile Sdn Bhd on the grounds of retrenchment was carried out with just cause or excuse. So the law is that the Industrial Court is a statutory tribunal established under the Industrial Relation Act and to adjudicate trade disputes. So the court is given jurisdiction when the minister refers to the trade dispute to it. Unlike civil court bound by rigid rules, the industrial court is actually required by the Act according to equity, good conscience, and substantial merit in the case. So what is retrenchment? Retrenchment refers to an employer's termination of excess employees for any reason other than as a disciplinary punishment. So in the case of William Jess and Cor versus S. Balasingham, the court actually held that it was within the prerogatives of an employer to manage his business as they saw fit. And however, this power is not as severe as it must be exercised for a fight. So the industrial court will interfere in cases where the restructuring is discovered to be disguised to victimization or unfair labor practices. So redundancy refers to the condition of having many employees doing the same job, and it is a necessary precondition for an employee to exercise the right of the retrenchment. So in the case of Bayer Sdn Bhd versus Mu Hong Pao, the court actually held that an employee must prove that there was a surplus of labor requiring the discharge of employees, and the burden of proof lies on the employee to show the actual redundancy actually existed. And in convening fairness, the court is required under Section 30, Clause 5 of the LRA to tap into the regard of the court conduct for the industrial harmony. So a critical principle in this framework is that last in, thus first out. So in order to deviate from the last in, first out, the employer must demonstrate that the junior's employees that are retained have certain skills that the senior employees do not have and cannot be acquired. In the case of Wu Chang-Seng versus Petchit Job Production, the claimant alleged that he was dismissed by Petchit Job Production without just cause or excuse. It was held that the burden of proof always was the owner of the company to show before the industrial court that the termination on the ground of retrenchment arising out of redundancy was for just cause or excuse, and that it was lawful and not actuated by irrelevant consideration like poor performance or perceived information. So in some case, the industrial court actually found that the company had failed to discuss its burden of proof. And also, Section 12.1 of the Employment Act identifies set out the requirements for either party to give notice of intention to terminate a contract of service. Section 2 of the Section 15 describes the minimum statutory notice period based on the length of continuous employment. So Section 13 Clause 1 of the same Act allows either party to terminate the contract while waiting for the notice period to expire by paying and identify equal to the wages that would have been accrued during the notice period. And additionally, a collective agreement is binding on all parties under Section 17 of the LRA. So therefore, failure to adhere to the terms of a collective agreement, such as requirements for prior consolidation, is viewed by the court as a breach of statutory duty and insurance justice. How about the views, Daniel?
Yeah, so by applying all the related sections into the particular scenario, Cyrus, acting under Section 30 Clause 5 of IRN, must determine the case based on equity and good conscience. Applying the principle in William Jacks and Co. Sendirian Berhad versus Balasingham Malay, Texas Sendirian Berhad holds the managerial prerogative to restructure its factory for court castings and modernizations. However, this power is not absolute. In line with Ng Chan Sang versus Technic Geo Productions and Mayer Sendirian Berhad versus Ong Hong Pao, the burden of proof lies strictly on Malay textiles to demonstrate that the surplus of labor was actual and not a gist of victimizations. But the management argues the restructuring was necessary for business viability. This might produce concrete evidence to Saras showing that the rules of the long service employee were indeed redundant due to the modernizations. If the modernizations could serve merit a pretext to remove older, higher paid employees without a genuine reductions in works, the retrenchment would be deemed mala fide. Additionally, compliance with statutory notice provision of Section 12 of the Employment Act, or alternatively payment in lieu provisions of Section 13 is an essential part of procedural fairness. In case where Malaya Textiles dismissed the employees without giving the stipulated notice or paying them an amount that were not in line with Section 13, it will be considered as a statutory breach. The allegations of the employees that the termination was not properly managed leave a strong suspicion that the termination requirements were not met. The facts state that several long service employees were terminated. This raises a rebuttable presumption that Malaya Textiles may have deviated from the last in, first out principles outlined in the Code of Conduct for Industrial Harmony. To justify retaining junior employees while dismissing senior ones, the company must prove to the court that the junior employees possess specific skill required for the modernized factory that the senior employee lacked and could not acquire. Furthermore, applying the principle of the Code of Conduct and Section 12 of the Employment Act, the employer has a duty to engage in meaningful consultations. The unions claim that there was no proper consultation, suggests that the company failed to explore alternatives to retrenchments. The union further alleged that the dismissal was carried out without proper consultation and in breach of the collective agreement. In industrial law, a collective agreement is a legally binding document. If such document mandates engagement with the union prior to the terminations, the company's failure to do so commit a substantive breach of Section 17 of the IRM. So, to sum up, as the president of the industrial court, Sarah should resolve the matter by filing in favor of the Textile Workers Union of Malaysia. The retrenchment exercise was fatally flowed by the violations of the last in first out principles, the breach of the collective agreements, and the disregard for statutory procedures under the Employment Act 1955.
Thank you so much, Jasper and also Sam, for clearly explaining to us regarding the issue 1, and also making it easier to understand by all the people who are watching this episode. So without further ado, let us ask Chen and also Kaur regarding the second issue. So Kaur will be explaining to us regarding the issue and also the law, while Chen will make it into application and also conclusion. Let's go.
Another issue in this case is whether the company breached the collective agreement and committed unfair practices. Though the industrial court is a statutory tribunal established under the IRA 1967 to adjudicate trade disputes. Not only that, but Section 26(2) of the IRA 1967 explains that the minister may refer any dispute to the industrial court on his own initiative or after receiving a report from the Director General. Under the Frank Committee, it indicates the system to handle the industrial disputes and employment-related complaints. The committee emphasized 3 basic characteristics in the tribunal procedure, which is openness. This means the tribunal hearings should be open and transparent. Next is regarding fairness. This means the procedure must be clear and fair. Lastly, the character is impartiality, where the tribunal must be independent and free from influence. Section 17 sub 1 of the IRA 1967 stated that once the industrial court recognizes a collective agreement, it becomes legally binding like a court award. Under Section 17 sub 2 of the IRA 1967, it stated that the terms in the collective agreement automatically become part of every worker's employment contract for the period stated in the agreement. This includes wages, benefits, and working conditions unless they are later changed by another agreement or co-decision. Section 20 of the IRA 1967 stated that if an employee believes they were dismissed without a just cause or excuse, they can write to the Director General to ask to be reinstated. However, they must file this representation at the Director General's office nearest to their former workplace. Section 30 sub 5 stated that the court shall act according to equity, good conscience, and the substantial merits of the case without regard to technicalities and legal form. In the case of Lily Industries and Sendirian Berhad against Billy Wayne Seltzer, the court clearly held that it has 3 principles. Firstly, there must be a conduct of redundancy. Secondly, the dismissed workman must have been correctly selected for retrenchment. And thirdly, the employer should have adopted a fair procedure before carrying out the retrenchment. These form the three pillars where the employer must provide clear evidence to prove redundancy exists, and the selection must be fair and proper retrenchment procedure must be followed. Thus, if the employer fails to carry out these three principles, then the retrenchment will be considered invalid.
Okay, so in this case, the sudden dismissal of the employees by the Maya Textiles Sdn Bhd without any consultation clearly indicates a breach of the collective agreements. So since the Maya Textiles Sdn Bhd and its employer have a formal collective agreements, so any requirement for the consultations before a redundancy exercise become legally enforceable once it is deposited and taken cognizance under Section 17, Clause 1 of the IRA 1967. Therefore, the Malaya Textiles Sdn Bhd failing to consult the Textile Worker Union of Malaysia before dismissing the long-serving employees constitute a breach of its statutory obligations under Section 17, Clause 1 of the IRA 1967. Next, the affected employees are entitled to invoke the Sections 20 IRA 1967 as they were dismissed without just cause or excuse. So the Maya Textiles Sdn Bhd employees can file a representation seeking within statements. When adjudicating this representation, SARAS must apply Section 30, Clause 5 of the IRA 1967, which requires the industrial court to act according to equity, good conscience, and the substantial merit of the case. It is important for SARA to follow the tribunal principles of openness, fairness, and impartiality. Applying this statutory provision to the present facts, it can be proved that the Maya Textiles Sdn Bhd did not conduct any consultations and it just directly terminated the long-serving employees. Ultimately, the Malaya Textiles Sdn Bhd failed to follow the terms and conditions in the collective agreement. According to the third pillar, under the case of the Lily Industrial and Sdn Bhd versus Lily Wayne Celsius Malaya Textile, it shows the proper procedures must be followed. In this present case, the Textile Workers Union of Malaysia claimed there was no consultations prior to the terminations. Therefore, the consultation is not just a courtesy, but it is a legally required where a collective agreement, in this case, exists. It can be proved that under Section 17 of the RA 1967, where the collective agreement is a part of the employment contracts, failure to consult is therefore a breach of the statutory obligation. Thus, the Malaysian Textiles Sdn Bhd failed to follow the procedure is a considered breach of the collective agreement. Therefore, in conclusions, I can conclude that the Maya Textiles Sdn Bhd breached the collective agreement and committed the unfair labour practice, and therefore their dismissal are unjust and unlawful.
Thank you so much, Kor, and also Chen, putting your critical thinking on identifying the issue in this case. And what stands out here is how crucial procedure fairness is in any retrenchment exercise. It is not enough for a company to claim redundancy, and Malaya Textile shows that they have followed a proper legal step, applying all the necessary procedure that has been required. But from what all of you have highlighted, Malaya Textile seems to have fallen short on several steps, and the long-serving employees were dismissed and without a clear justification. Seems like it is not unfair for the party. And this shows that even if redundancy may appear genuine on the surface, the industrial court will still rule the dismissal unfair if the employee ignores the required procedure. That's something that we need to highlight over here. Process matters just as much as the reasons behind the retrenchment. With that, we can clearly see why issue 2 strengthens the union case even further. And in short, tribunals are vital pillars of our legal system, ensuring justice is fair, accessible, and also specialized. They protect rights, resolve disputes efficiently, and make the law relevant to the ordinary people. And that's exactly what we aim to do here on Admin in Action, where they break down the legal process, show how they touch in real lives, and make the law understandable and relatable to the people. Huge thanks to our panel for showing us how one dispute can have two different INEC stories. Join us next week when we reveal another legal puzzle with a dash of humor and a lot of law. So until next time, remember our mantra, Admin in Action, where the law meets life and justice for everyone.